Welcome to our clip on the work product doctrine. We'll start with a survey of the seminal Supreme Court case of Hickman v. Taylor. Then we'll use Hickman as a backdrop to discuss Rule 26b as in boy, Section 3. Rule 26b-3 states the modern rule, the exception to the rule, and the exception to the exception, all of which we'll discuss in this clip. Now let's survey Hickman v. Taylor. On February 7, 1943, a tugboat sank in the Delaware River. The boat was tugging a railroad car float. 5 of the 9 crew members died. A short time later, the tug owners and their underwriters hired a lawyer, Mr. Fotenbaugh, for the purpose of defending them in the litigation that they smelled coming. After the accident, the U.S. Steamboat Inspector held a public hearing where it examined the 4 surviving crew members. This testimony was publicly available. Shortly after the hearing, Mr. Fotenbaugh interviewed the survivors and obtained signed written statements from them. Mr. Fotenbaugh also interviewed other witnesses to the accident. He made various notes and memoranda of these conversations as he deemed appropriate. Of the 5 lawsuits commenced by the families of the dead crew members, 4 settled, but 1 made it to the discovery stage. Counsel for the plaintiffs, Mr. Friedman, sent discovery requests to Mr. Fotenbaugh. One of these, boiled down, would have required Mr. Fotenbaugh to turn over the signed statements by the surviving crew members, as well as Mr. Fotenbaugh's notes, observations, memos, and recollections about his conversations with the witnesses. Mr. Fotenbaugh objected strenuously to the requests. The district court held that the materials had to be turned over, but the Third Circuit Court of Appeals held that they didn't. The Supreme Court on Appeal also held that they didn't. The reason that the Supreme Court took the Hickman case was the great division in the cases over the issue of whether or to what extent the discovery tools may be used to obtain an attorney's work product made in anticipation of litigation, since the materials that the plaintiffs were requesting really consisted only of Mr. Fotenbaugh's work product. Now that we've encountered the term work product, let's step aside from Hickman for a moment.